case briefs, and so much more. LSData's got what you're looking for.
In the 1991 Supreme Court case Cohen v. Cowles Media Company, the central issue was that journalists and the press must follow the same laws that apply to everyone else, unless there is a very good reason not to. The situation began during the 1982 Minnesota gubernatorial race when Republican campaigner Dan Cohen provided confidential documents to two newspapers. In exchange for this information, he was promised confidentiality by the publications. However, when the newspapers published articles that included information from the documents and interviews with the Democratic farmer-labor candidate, they also revealed Cohen as the source despite their initial promise. Cohen sued the newspapers for breaching their contract and fraudulent misrepresentation. The lower court ruled in Cohen's favor, stating he could claim damages for violating the promise of confidentiality. The case was eventually elevated to the Minnesota Supreme Court, where the decision focused on whether enforcing the promise would violate the newspaper's First Amendment rights. Ultimately, the Supreme Court concluded that the First Amendment is not a blanket protection for the press when it comes to breaching confidentiality agreements. The court held that the Minnesota Supreme Court erred in awarding $200,000 in compensatory damages to Cohen, reversing the judgment and not reinstating the jury verdict. The case was remanded to address whether a promissory estoppel claim was established under Minnesota law.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsc.law, elevate your mind. Leave the stress of class.